We're live.
All right, good morning, everyone. We got Wednesday, May 14th, a little after 10 a.m. We're continuing work on S 131, an act relating to approval of an amendment to the charter of the city of Burlington relating to possession of firearms. And we have with us Eric Patrick from Legislative Council. And he does not spend much, if any, time in this room. So welcome, sir. It's good to see you.
Thank you very much, and nice to see everybody. As the chair said, Eric Fitzpatrick with the Office of Legislative Counsel. And no, I haven't been in this room this session, not since they remodeled. So thanks for having me. And happy to be here on S 131, which is an act relating to approval of the City of Burlington Charter Amendment relating to firearms possession in places that are licensed to serve alcohol. And as the chair indicated, I haven't been in this committee primarily because I'm usually in the judiciary committees. That's where I am most often. And one of the issues that I cover there is firearms. Hence my being here today to help the committee get a handle on the piece of the charter that has to do with firearms. I know there's also quite a bit of it that has to do with alcohol licensing and local municipal government. So it's sort of a team between myself and Tucker who've worked on this bill. And I heard from Tucker that he wasn't here and was able to talk to the committee a little bit about those aspects of the bill. But I can fill the committee in on whatever questions you may have with respect to the firearms piece. First of all, give you a little bit of background of what that language is all about and how I see it fitting into the constitutional structure, which is very important. So does that sound like a good way to proceed, or is there anything specific that?
Let's start with that and kind of like build off. Yeah.
Okay.
I think that would be a great place to start.
Great. Great. Well, as I'm sure folks have seen when they looked at the language of the Polish charter, what's going on here is that it's proposing to ban the knowing possession of firearms in any premises licensed to serve alcoholic beverages. So that's the language that was in the charter, or at least it's the language that's in the amendment as it came over from the Senate. Actually was not the language that was in the charter that was approved and voted on by the city of Burlington. That language prohibited firearms, not just in the premises that was licensed to serve alcohol, but it also included the adjoining parking lots or any other portion of the building that was owned by the licensee, and actually any other property that the licensee owned. It's a little unclear. It might not even have to have been anywhere near the licensed premises. So that was the language that was passed. In my view, that was pretty clearly unconstitutional by regulating possession of firearms in places where the state doesn't have the authority under the Second Amendment to regulate firearms. So that was the opinion I gave to the Senate Government Operations Committee, and we redrafted the language to be what it is now, which is limited and targeted to prohibiting firearms see the key word in places licensed to serve alcohol. It doesn't apply to outside those licensed areas. So the reason that my view is that language is constitutional under the Second Amendment goes back to not that far back, but it's a very, very important, which even people who aren't necessarily very familiar with firearm stuff may have heard of this case, which is called the Bruen case. Everyone refers to the Bruen case now from 2022, Bruen versus the New York State Pistol and Rifle Association. And that was when the United States Supreme Court laid down what the test is now for when a state or a local municipality proposes to pass a law that impacts people's firearms rights. And the test is, that kind of legislative restriction may be constitutional, it may not be. Depends on, according to the Supreme Court, whether or not the proposal is consistent with the nation's history of firearms regulation. That's the key phrase. Is it consistent with the nation's history of firearms regulation? And as you can kind of, deduce from that sentence, that means history has to be studied in order to determine whether or not this proposed regulation is constitutional or not. And that's what the court said. What you have to do is look back in history, see, has there been a history of regulating firearms in this way? Or if it's not exactly in that way, in other words, the court used the phrase, if it's not an identical twin, and you don't have to find an identical twin, the court said, then it has to be something comparable, something analogous. Is there some history of regulating firearms in that kind of that kind of approach. So that's what the court said. The court also said, and this is very important for S-131, the court also said there is actually a longstanding history, it used that phrase, longstanding history in the country of regulating firearms at certain sensitive places. So this has become what's known as the sensitive locations principle, because the court specifically identified, hey, there's an approach that there is historical support for. And in that Bruin case, the court said, hey, look, here's these 5 places that, for example, there's been a history of regulating firearms. It said appropriately and helpfully for you guys, legislative assemblies was one of them, courthouses, government buildings, schools, what's the 5th one? Courthouses, polling places, which was also passed the legislature recently. So you got these 5 things. And of those 5, actually, Vermont has 3 statutes already that make it, that prohibit possession at 3 of those 5. Courthouses and schools were actually, which have actually been on the books for quite a while, since the late 90s, early 2000s. Additionally, the legislative assemblies was a statute that was passed, as not legislative assemblies, polling places was passed a couple of years ago, the criminal statute prohibiting firearms there. And then you also have government buildings and legislative assemblies. Those actually are, firearms are prohibited in Vermont at those places, but it's by rule, not by statute. So like the BGS has a rule prohibiting them in government buildings, and the Sergeant at Arms has a rule prohibiting firearms in the General Assembly building. So those are approach. You may also recall, I think also a couple of years ago, one that wasn't on that original list that the Vermont legislature passed was hospitals. Remember that a couple of years ago. And these are all within this category of location restrictions. In other words, it's not about the type of firearm or whether it's some connected kind of weapon or who may possess it, you know, how old the person is, whether they have a certain criminal convictions. That's not, it's all this type of regulation called a location restriction. And what the Supreme Court has said is that that's okay. The sensitive places are okay if either there's a history of regulating firearms in those kind of places, or at least, you know, again, as I said, it doesn't have to be an identical twin, but at least something comparable. So again, you're going to have to look at the history to see if, and the court said, if you're going to add new locations, you got to do this historical analysis to see if it's either been done historically or at least been done in a comparable kind of place historically.
Rebecca?
Quick question for clarification, please, and I should know the answer to this. What did you just say about hospitals? I was writing.
No, that's okay. Absolutely. Yeah, I talk fast anyway, so feel free to slow down. Yes, Vermont passed the statute that prohibits possession of firearms in hospitals. I think it was 2 years ago now.
I remember that, but I just didn't know what category that fell into, whether it was statutes or
Rule. Yep, it's a statute now, as of a couple of years ago. Yep.
Thank you.
Yeah, absolutely. So that's a little bit of the background. So you have this principle of being able to regulate firearms at certain sensitive locations that the Supreme Court articulated. So what you have in front of you, what the city of Burlington has proposed is another location, right? Places that serve alcohol. So no, that's a location restriction based on whether or not you're licensed to serve alcohol. So what sort of springs to mind is how does one analyze that under the Second Amendment to see if that might be constitutionally permissible? Well, you have to look back in history, right? And see if is there any kind of historical tradition in this country of regulating firearms at places that serve alcohol? Fortunately, for this particular legislative proposal, the question has already been answered by with that respect to that particular sensitive location, which is places that serve alcohol. The United States Court of Appeals for the Second Circuit, which is the Circuit Court of Appeals that includes Vermont. So you've got Vermont, Connecticut, New York, and within the federal court system are all within the Second Circuit. The United States is broken up into about a dozen different circuits. And, the United States Supreme Court only rules on, plus or minus 75 cases a year. So much more federal law for a given state is actually, in terms of quantity, is set by the circuit courts than it is by the U.S. Supreme Court, just by virtue of the number of cases they hear, which is a lot. And the Second Circuit happens to have heard a case that involved New York's statute that prohibited I'll read it for you, very similar to what is in S-131. New York statute prohibited possession of a firearm in any establishment holding an active license for on-premise consumption of alcoholic beverages where alcohol is consumed. So functionally, same thing as what you're looking at from S-131. And this was challenged in the New York Federal District Court, went up to the Second Circuit, and the Second Circuit squarely ruled just a few months ago in October that approach is consistent with the nation's history of regulating firearms and therefore is permissible under the Second Amendment. And it looked at specifically, it's interesting, there's a number of different older laws, because that's what you do. You have to look at history. For example, I found a couple of 1867 from Kansas, 1889 from Wisconsin, 1883 from Missouri. These were statutes that prohibited intoxicated persons from carrying firearms. Again, a little different than a location restriction, but conceptually in the ballpark. But then it did find to what it referred to as historical twins. And those were interesting. So from Arizona session laws, 1889, required keepers of drinking saloons to keep posted up in a conspicuous place in his barroom a plain notice to travelers to divest themselves of their weapons. That's Arizona, 1889. 1890, Oklahoma territories, the law prohibited carriage of firearms in any place where intoxicating liquors are sold. So the court, Second Circuit, looked at all those things together and said, look, there's this history of regulating firearms. The firearms and alcohol don't mix. There's been a couple of places specific, and it looked at all those together and said, all right, these, and actually there was another one as well, Wisconsin one that prohibited anybody from carrying a firearm while they were under the influence. And it said those six analogs, by 1889 applied to almost 10% of all Americans. If you sort of added all the people who are living in these territories, said that's sufficient historic tradition, and therefore it's permitted. So interesting. Oh, sorry, go ahead.
Oh, no, go ahead, finish your sentence.
Well, so there's just interesting that there's been only two, as far as I know, two circuit courts that have ruled on this firearms in places that serve alcohol question. One happens to be our circuit, the Second Circuit, which from a lawyer's perspective is very helpful because it's not often that you have a case that's right on point that is actually binding authority where you are, but we happen to in this case. But the other one was from the Ninth Circuit, which includes Oregon, Washington, California, Hawaii. And the Ninth Circuit looked at two state statutes, one from Hawaii, one from California. The Hawaii statute prohibited the carrying of firearms into, remember that word, any bar or restaurant serving alcohol or intoxicating liquor. California statute similarly prohibits carrying of firearms in and establishments where intoxicating liquor is sold for consumption on the premises. Similar analysis, the court had to go through this history of what did they find, found a few other ones that are interesting. 1853 New Mexico prohibition on firearms at a ball or fandango. I don't know if they defined
that word.
Fandango. Yeah, I know.
It's defined for the purpose of.
Yeah, I should have looked that up.
Yeah.
And at any room adjoining said ball where liquors are sold. 1870s San Antonio, Texas banned firearms at any bar room or drinking saloon. 1879 New Orleans banned firearms at any public hall or tavern. I also looked at the same Oklahoma territory statute that the Second Circuit looked at that I mentioned earlier, looked at all those and said, hey, these laws, this is quoting, these laws establish that bars and restaurants that sell alcohol are among the nation's sensitive places where firearms may be prohibited. So squarely on point.
So my question, thank you, is to go back to the October of 2024 Second Circuit Court
Yes,
decision.
right.
Can you tell us a little bit more about that case, what it actually involved? You said it was very similar to what Burlington is proposing.
Yes, so this case was called Antoniuk v. James, and it involved a number of locations, not just that one. There's a long list of location restrictions that were in a New York statute that was passed by the state of New York, and they were all challenged on their face by a number of different folks who said these are all unconstitutional under the Second Amendment, and specifically under the Bruin test that I just described. Because they say the Bruin test, relatively recent case, 2022, and these cases take a long time to work their way through the courts. So that was 2022. And there was actually a lot of back and forth between New York and the Supreme Court in this context, but without getting into too much detail on that, the point was that in response to Bruin, New York passed a law that prohibited firearms at a number of different locations, and the Second Circuit and well, some federal district courts as well. But the Second Circuit had to go through all these locations and do a historical analysis on each one. And it sounds some were okay, some weren't. But one of the ones that it analyzed was the the portion of the New York statute that I read that prohibited possession of firearms in establishments holding an active license for on-premises consumption where alcohol is consumed. So that was the New York statute. The Second Circuit had to look at that and analyze it under that Bruin test and say, hey, is there a history of that sort of thing in the United States? Or at least is there a history of something analogous or comparable to the other locations that the Supreme Court in Bruin had said there was a history of? They didn't have to do that part of the analysis. They didn't have to do any sort of analogizing because they found some specific, what the Bruin court referred to as twins. In other words, they're right on point in terms of they actually did these historical statutes in Arizona and Oklahoma actually did prohibit firearms in places that serve alcohol. And there were another sort of analogous ones, but looking at all those together, the Second Circuit said this is a permissible regulation of firearms that states can do. And as it happens, when the Second Circuit says states can do it, that includes Vermont because we're in the Second Circuit along with Connecticut, New York, and
Just to go back,
yeah,
as you do talk fast. And
I know. Sorry about
it's
that.
quite that fast.
Not at all.
The suit in the Second Circuit Court
Yep.
alleged unconstitutionality under the Bruin case. And
Yep.
one other point, which I missed that you said two things, that it was
Second Amendment. Yes, the sort of the Bruin test under the Second Amendment.
okay.
Yeah.
I had Rep. Huber and then Rep. Morgan. Unless Rep. Morgan appears to be deferring.
Guess he's going to yield to me.
He's yielding the number.
Thank you, members of Berlin. Eric, in its journey in the Senate, was the Vermont Sportsman's Bill of Rights addressed in terms of when it talks about inconsistency amongst municipalities?
Yes.
Was that addressed?
Yep. They talked about that. It was primarily Tucker because it's more of a municipal law sort of thing, but I can, without putting words in his mouth, I could sort of articulate what he said in the Senate, which is that as a law that's passed, this, first of all, the Sportsman Bill of Rights, this term that refers to a couple of places in state statute where there's a provision that says, notwithstanding unless otherwise permitted by law, the state municipalities can't pass ordinances that regulate possession of firearms, that sort of thing. I think Tucker responded that, well, it says unless otherwise provided by law. So that permits the legislature to otherwise provide by law, if you so decide. So in other words, if you were to pass this, and whether you want to or not as a policy matter is up to you. But if you were to choose to do that, that would be a instance of the state providing otherwise by law that a particular charter change would allow the city to regulate possession of firearms. So it's
Even though it's a one-off,
yeah, even though it's
so they don't consider that inconsistent.
right for that reason. Yeah,
Interesting.
Yeah.
Kind of read it a little differently, but that's just the way I'm reading it.
right.
Maybe that's.
Well, it's a
I'm not an
good.
attorney.
Yeah,
I'm asking
well,
you.
it's still also, as I say, I think something that Tucker has a little more familiarity with. So
Yeah.
when he's back in,
Sure.
I'd suggest follow up with him on that point as well.
Okay, thanks, sir.
You bet.
Representative Hoover.
So we use the word premises. The location.
Right.
And we talked a little bit with Tucker about intervening public access ways.
Yep.
This happened on the spur of this happened on Church Street. Not in a place that's premises, but out on public walkway. They have a tendency, some businesses, Sweetwater, will off the entire area of Church Street without public access between their business and the area.
Mhm.
Some other places, they'll still be able to walk down the sidewalk part. This is city property that they've either leased or whatever. It's probably tough to get to the point where premises.
And it may not be. This is again, something I've spoken with Tucker about because it has to do with sort of how the licensing scheme works. But my understanding of it is use like, whether it's Rera or Sweetwater as an example, or Lunix, they all have similar kind of things, or at least where they have some tables, that are out sort of in the walkway part or more towards the center of Church Street. And then you have a walkway where people can walk by even if they're not customers, like say you're just walking by.
That Sweetwater's is the difference. They put a chain up.
Oh, you have to go around. Right, interesting. I think my understanding of it is that it really is going to depend on where the license applies. So the licensed premises, I think, is quite specific. Again, this is Tucker's area of the law, but from talking to him, my understanding is like these licenses, and you probably would know this better than me, specify what the license area is.
Defined outdoor consumption area, which is part of the licensure process for outdoor consumption. It is approved by the DLL. It is a mapped out area. So that is the licensed area where this restriction would hold place.
Right. And if it's not part of that licensed area, just as somewhat hypothetically, but let's say, for example, at one of these establishments, the licensed area was the tables that was closer to Church Street and the other part that's closer to the restaurant, but that sidewalk that passes through is not part of the licensed area, then a person could carry their firearm as they walk down that sidewalk and would not be a violation because that's not part of the licensed premises. On the other hand, they couldn't take it into those tables that are closer to Church Street, again, presuming without knowing that that was part of the licensed area. It's the way I think it would operate. Might be a bit of a trickier situation if the establishment has chosen to rope off that whole area, but that would really depend on what does their license say, right? Does their license say, whether you rope it or not, if your license says that that intervening sidewalk is not part of the licensed area, then you could still carry it there, the way I read it.
The city has subsequent board level for approval, things like that.
Yes, all of the liquor licenses for second, third class, fourth class get approved at the state level and a municipal level. So there's like a two-step process to those license acquisitions.
Is that in all municipalities?
If so. And it's usually either the select board, municipal board itself, and sometimes in a large municipality, they may have like a subcommittee that takes a look at it, but it's done at the municipal governance level.
A couple other things to add that are just also important changes to the language as it was passed by the city. The city's language didn't include what we refer to as a mens rea, which means a mental state. So we added the word, as we have in all of our statutes, knowingly. Person may not knowingly possess, because the idea is that you don't want to criminalize if someone accidentally, maybe they inadvertently, maybe they ran out of the house really quickly and they didn't remember that they had their firearm on their person. It's something that came up in the hospital statute last year or 2 years ago, because people were concerned about, because sometimes you will end up in going to the hospital under emergency circumstances. You're not thinking about the fact that you're still in possession, and they didn't want to criminalize that. Similar, and all of the location restrictions that Vermont has in statute had this knowingly standard. You have to know both that you have the firearm and that you're in this case, in an establishment that's licensed to serve alcohol.
For Burlington.
You bring it up and remind me that what we did with the hospital, expand the people who were allowed to carry as part of the job. That's Secretary of State's office, our investigator, something we have not done that. That's fine.
Right. There are several exceptions. And those are, at least on my subdivision 2, pages 2 to 3, like law enforcement officers, armed forces, government officers, agents authorized to carry weapons within the scope of their duties, and the holder of the license. Those are all exceptions. So those people can possess. And there was some discussion about whether or not, managers or security, you know, because bars sometimes have security who work there. They talked about that down in Senate GovOps, and they just ultimately decided that, and they heard testimony, in fact, from one of the licensees in Burlington. And based on that, they decided that maybe it wasn't the right route in this context. But a policy decision for you guys.
Rep Hango, and then I have a question as well.
So these exceptions, the first one, any federal, state or local law enforcement officer acting within the scope of that officer's official duties. So that does not cover a law enforcement officer who may be off duty and still carrying his service weapon.
Correct. And I should point out that language is boilerplate you'll see that in a lot of the firearm statutes, that's just cut and pasted from the way that's ordinarily phrased. And it's the same with the next one down, subdivision B, the military folks, same thing. Yeah, within the scope of their military duties, and also the government agent subdivision C, it's all the same thing. So in other words, the policy decision was not to exempt them if they just happen to be carrying their weapon, but they're not on duty. Exactly. Sorry, I'll defer to you.
Yeah, I had one question about unknowing possession.
Right.
How does that work?
For example, you inadvertently, maybe you have your firearm concealed carry a lot of the time, and you're just not, whatever, you're going out of the house quickly, you don't think about it, you're not remembering that it's on your person. So that's one way. You have to know that you possess it. If you forget or you weren't aware of it because of the circumstances, then it wouldn't be a violation. That's and you also have to know that you're on a premises where that's licensed to serve alcohol. So in other words, let's say you're in the parking garage and that's not covered by this, but it couldn't be either. You have to know that you're, and in fact, there was a case specifically on that talked about the knowing possession issue. But the idea, the concept is that you couldn't, for example, be prosecuted if you thought, well, actually, a good example would be if for some reason we were talking about the walkways in Church Street, for example. Let's say in a given establishment, again, I don't know how the licensing systems work, but if for some reason somebody's license included the walkway that went through, and you're walking down thinking that, oh, yeah, the walkway is a place where I can carry, then and you get prosecuted for a violation of the ordinance. And again, I don't know the licensing system well enough to say that if it's even possible for them to have the license apply to that narrow walkway. But in the example, let's say they did. And you were carrying, thinking that, hey, this is a place where I can carry because the license doesn't apply here. Couldn't be prosecuted for that because you weren't knowingly in a place that was licensed to serve alcohol. You thought that it was a place that was not licensed to serve alcohol, or a place where the license didn't apply at least.
So, I mean, couldn't anybody just claim that they didn't know?
It is a matter of proof. Exactly. Yeah, it's a matter of proof. But the knowingly standard, it's a standard that the courts are familiar with, that prosecutors and defense attorneys are familiar with. They know the sorts of circumstantial evidence that you have to bring forward to show that that the person actually did have knowledge that that's what was going on.
Are there instances in court where it was claimed that they didn't know and the evidence the courts were proved that they did know?
One more time, sorry.
Are there any examples of court cases where somebody in a situation like this with the other aspects of restriction, where somebody claimed to not know that they weren't allowed to bring it in, and then the courts proved that they did know?
Oh, yeah, absolutely.
Okay.
Yep.
And what would that look like in a court case?
Oh, for example, they could introduce circumstantial evidence that, the person claimed that they didn't know they were in that location. And again, it's not that you have to know whether or not they're licensed or not. It's knowing that that's where you are.
Okay, I got you.
So they can say, oh, well, the person maybe said, I didn't know that I was going into the bar. They can say, well, look, the person spoke to the bouncer or the person at the door and was clearly paid the, a cover charge or had a discussion that indicated that they knew they were going into the place where they were going to buy a drink. So those sorts of things.
Okay,
So you could say,
unknowing of the location, not unknowing that they had the firearm on them?
no, knowing that they had the license. They have to know they had the firearm. Yes.
Yes.
Yeah.
So it's not about like not being aware that you have like a firearm in your bag. Somebody absentmindedly has a firearm in a bag.
No, that could be a defense. Absolutely.
Yeah, and so I think that's what I was more asking,
Right.
was an example of somebody who unknowingly had a firearm on their person. In
Oh, yeah.
an establishment. Are there
Yes.
cases with that scenario?
I don't know if there's any, I haven't know if there are any specific court cases, but I do think that scenario is exactly the type of, for example, in the hospitals one, that's what was contemplated. This idea that someone, because they were in an emergency situation, had to get to the hospital ASAP.
Fair.
And as you say, didn't remember they had their firearm in their backpack, for example, but brought it along with them. They didn't want that person to be prosecuted. So yeah, the person could defend and say, I had to go really quickly and I just grabbed my bag and I forgot that it was in there. Yeah, that could be a legitimate defense.
Representative Hoover.
I think it happens more in the winter when you have a lot of junk in your coat pocket.
Right, could be.
No notice requirement. Post, no smoking signs, things like that. Seems to be absent here that you're entering a no firearms zone.
Yeah, a policy decision for you. Like you do have a notice requirement in the hospital one, for example. That is an option.
Zampango, I do want to be aware that Chief Burke is with us.
Sure. Just one last question, and it may be a question for Tucker. Licensees, there is an exemption for a licensee to hold, the holder of the license for the establishment that serves alcohol. There's an exemption for them to carry. Are individuals a licensee of these establishments, or are they corporations, or are they groups? Do you know?
I know I'll defer to Tucker on the more detailed answer, but I can give you the big picture answer just because that same question came up downstairs and spoken with Tucker about it a little bit. And the answer to that is there's some of each.
Okay.
Sometimes it's an entity, a corporate entity of some kind, an LLC, a corporation, what partnership, whatever it may be. And other times it's an individual. So
Yeah, I would like that differentiated because you can't exempt a corporation or exempt a group of individuals who are like a restaurant group, for instance, from carrying.
but yeah, I think that's right. And that the answer is that as a practical matter, that exemption would apply only if the license happened to be held by an individual.
And Rep. Waters Evans, and then I want to get to Chief Burke.
No, it's okay. I was just going to clarify what Tucker told us last week about that, but we.
Okay.
Thanks.
Anything else for Mr. Fitzpatrick?
Just one last brief thing, because I hadn't got a chance to get to the penalties.
Oh,
Just so you see, there's
Yes, please.
it's an optional criminal or civil penalty. So it depends how the law enforcement officer charges it. That's sometimes done in the criminal law. DUI, for example, has both criminal and civil penalties. So it could be a criminal offense of 90 days imprisonment or not, and these are not more than, it doesn't have to be that much. It could be nothing, it could be all suspended. Or it could, it doesn't have to be a criminal offense at all. It could be a civil offense, which is really just very similar. Think of it as a traffic ticket in the Judicial Bureau. That's what a civil offense is. So it could be that kind of thing as well. There's some discretion there for how it's going to be charged.
Anything on that piece from the table? Really appreciate your time and knowledge on this. So
Happy to help and any other questions that come up, or if you want to have me back in to talk about any of this stuff, but always happy to come help however I can.
Appreciate that very much.
Thank you.
All right.
And next we have Chief Sean Burke, Burlington PD. How are you doing, sir? How's the new job treating you?
Good morning. New job's fantastic. Thank you so much, and appreciate you having me in today on this bill.
Excellent, excellent. Having never been here before, I believe, at least this biennium, I guess we'll do a quick introduction for you. Representative Matt Byrong, I represent Northwest Addison County, Chair of the committee.
Representative Lisa Hango, Vice Chair. I represent Franklin 5, which is on the Canadian border.
Representative Lucy Boyden, I represent Cambridge and Waterville.
Sandy Pincinella representing Dorset, Danby, Mount Tabor, Land Grove, and Peru.
Michael Morgan and all the Grand Isle County towns of Alberg, Lamont, North Bureau, Grand Isle, South Bureau, and west portion of Milton. We met.
Bob Hooper, the city up in the Northwest.
Bill Coffin, Cavendish, Weathersfield, and Baltimore.
Hi, I'm Shay Waters Evans from Charlotte and Heinsberg.
So yeah, so we're obviously we're taking up work on this charter request, and we were interested in hearing from you as the head of the law enforcement entity within the municipality about sort of like the perspective from the PD on this proposal. And I guess we'll sort of start there with your perspective from a municipal law enforcement level, and then a little bit of Q&A.
Sounds fantastic. So just by way of introduction, my name is Sean Burke. I do have the privilege of serving as the interim chief here in the city of Burlington. I've spent about the last 30 years in Vermont municipal law enforcement. I started in Woodstock. I came to Burlington in 97, served the city of Burlington 97 to 2018, served then as the chief of police in the city of South Burlington 18 to 25, where I landed in the interim role back here in the Queen City. So appreciate the committee taking testimony on the proposed charter change, and really from a public safety perspective, a couple different things. One, this was a charter change that was overwhelmingly approved by the Burlington voters. Two, your gun violence in our downtown, centric to nightlife activity is not new, but we have seen some alarming trends in recent years. And when I'm done talking, I've got a slide I can pop up on the screen to show you what the data looks like. What I practically see from this proposed charter change is an ability to empower licensed establishments to do things such as post their establishments, the firearms are prohibited, screen potential people entering the venues for firearms. City of Burlington has a lot of licensed liquor establishments downtown that are often the source of conflict that result in what we see in terms of gun violence in the street, and hopefully a way to kind of shift our culture here in town away from having guns and alcohol mixed, especially in the late night hours. I've heard a little bit of some of the questions that the committee had for Ledge Council on this issue about intent, knowingly, how the cops approach this type of work. And I'll tell you, we're very judicious in this way, and it's really akin to the work that our staff is doing now. We have an airport division that covers the Burlington International Airport, and oftentimes folks traverse or find their way into the security checkpoints with a firearm or ammunition or magazine that they had forgotten in a bag. And suddenly they're, in the stress of TSA, there's this federal requirement, and our officers have to go down there and navigate, A, are they a lawful possessor of a firearm? B, is there going to be any regulatory action taken by federal authorities in this regard? And then how do we figure out, how can this person get the firearm or item secured and then get back through screening and onto their airplane? So again, it's not necessarily nuanced work, but it's one where the officers really are judicious in their investigation. And like with any specific intent crime, we have to prove that burden immediately for a probable cause standard. So all of this would take, several investigatory steps that we're well versed in. Really, I think this is an extension of licensee regulation and how these venues are ultimately controlled. And I think it could be quite effective in that regard. Having said, those higher points, I want to leave plenty of time for question. Let me see if I can share my screen to just show you a little bit about how our data looks. Can everyone on the committee see that okay?
Yes.
Yeah, so about the last 9 years here, these are incidents that occurred in about a 6 block by 3 block swath of downtown. So if you can just visually see the Church Street Marketplace and see south 2 blocks to Maple, and then west toward the lake, a couple of blocks down to Pine Street, and then 1 block east up the hill toward the university to Winooski Avenue. This is the geographic area that this data was extracted from. And this is, every day of the week for each year, every hour of those days. And you can see the number of crimes that we investigated that involved firearms. So back in 2015, I was the Detective Bureau lieutenant, and one of those 6 was an actual homicide that spilled out from a nightclub on Lower Church Street. You can see the downward trend toward the pandemic, and then coming out of the pandemic, we had an alarming jump in 2022, which was really well televised by the media for good reason, and now a taper in that regard. And what the last bar in 2025 shows is that although we've only had 3 incidents thus far in 2025, assuming normal projections is that light gray section of the bar. So we hope through good policing and partnerships with the public safety apparatus that we have here in the city of Burlington, part of that team being the folks that actually are responsible for the safety and security in nightclubs, that we can keep that number a little bit lower than 9 in 2025, but that's a bit of wait and see. The number of incidents in 2022, 2023 are really alarming to be that high. And I would say, in 24, 9 incidents is 9 too many. And I don't know, given American gun culture, the availability of guns in this country, if we'll ever get to a number of 0. And I will confess that, I am a gun owner, a responsible gun owner, and really think long and hard about these regulations. But it just seems to me that a charter change such as this, engineered to really empower our liquor license holders to have additional regulations that would enhance safety in Vermont's largest city, is a sensible piece of legislation. So now, if I am clever enough with this to stop sharing, in return, I'd be happy to answer any questions.
Representative Boyd.
With the chart that you just shared with us, the gun-related incidents trend up after 2019. From your perspective, are there any other details that might correlate with the trended increase?
I'm sorry, they trended upward after what?
2019, and just from your perspective, are there any other details that might correlate with this trending increase?
Yeah, I mean, anecdotally, we had more people that were carrying guns that were in conflict with one another, and through strategic prosecution under Chief Murad and the team, then they were held accountable for their behaviors, and we saw a downward trend. But I know that each of those incidents isn't directly related to the bill under consideration here, in terms of they weren't all at licensed liquor establishments. But I will tell you, in my history with the city in the earlier years, that many of those were directly associated to disputes that happened in nightclubs that then spilled out onto the street that erupted in some type of gun violence.
Any other hands right now? Chief Burke, what are your current staffing levels right now? How many officers do you have full time?
Yeah, so we've got 63 police officers. That includes my 1 officer at the academy and the chief standing here before you. Our uniform patrol division has about 28 officers assigned to it right now. Our detective division has 10 detectives assigned. We have to have 6 at the airport. And then we have a couple of other extraneous positions. But we're really lean at night. Looking out toward our summer projections here in 2025, on any given night between when the nightclubs are active, so from 10 p.m. until about 3 a.m. On a good night, we'll have 8 officers and a supervisor. On a typical night, it might be 5 officers and a supervisor.
What is a healthy or fully staffed department look like to you?
Yeah, I mean, ideally, we would have on our day shift. So we work a 10-hour patrol schedule here. So there's overlap in how the shifts work. And really, the overlap is used during busier times, obviously, in the city. Ideally, we would have 8 to 9 officers on a day shift, 8 to 9 officers on a evening shift, and 5 officers on a midnight shift with then the supervisors on above those levels. But we are a long way out from achieving that.
Okay, so I have followed the department's staffing issues for a long time pretty closely. So my understanding is like a healthy, fully staffed department somewhere in like the high 80s, mid 90s.
90 would be a great number.
Okay.
Most of my tenure here, I think we're right around 93, and we can get what we need to get done.
Okay.
So the city fights a little bit above its weight class in terms of what we offer, civic events, other expectations on the police department. So when you look at like typical population to police officer ratios, it's not quite accurate here. Then there's just the reality of how many cops we can actually hire that we want to employ. How many of those applicants can we get successfully through the training program? And what's that look like against our normal attrition in terms of retirement, or folks that identified this profession as something that they wanted to do, almost like a military enlistment. They wanted to serve, be part of something bigger than themselves, but then decide to move on to another opportunity. And I think that's generational.
Totally got you on like the inner workings of the staffing. So my question is how do you prioritize calls as they come in with a low staffing level?
Yeah, so right now we've got a matrix that is used that the previous Chief Murad had put in place. It really doesn't empower the officer in charge to use their resources as needed. And that's always been how police departments work. Certain calls, you'll hear a dispatcher come on the radio. I need 2 units to break to go to a violent domestic. I need 2 units to break to go to a disturbance at a bar. And we do that in the moment with what we have. And we rely on some mutual aid assistance, largely that comes from the University of Vermont Police Services. They've been very essential in our response posture over the last few years, but we try to handle our work ourselves. And that also complicates retention in terms of a burnout factor.
Okay. So I guess like I thought from conversations with people that there was sort of like a prioritization is like the calls come in where more violent things are prioritized, or maybe like a B&E where there's nobody at the house, just like a vacated premises that had been broken into. So I guess my question is where would a call from a licensed establishment fall into this prioritization?
So to be blunt about this, the priority response plan is going to be rolled back, and we're going to empower the officer in charge to make operational decisions in the field, because that's how you get this work done. In terms of the context around any given encounter that's reported in our dispatch center, that's where the importance lies in the work. So if they need you at a certain bar because they've got an unruly patron that's possessing a firearm, refusing to leave, that's going to be an immediate response call. Things that a noise complaint in the Hill section, loud party, people with open containers, those things can wait. To use your burglary example, a lot of folks report burglaries, but the other detail is they don't know if anyone's still in the house. So we will try to get to that call immediately. It's different if a business owner comes into their place of their establishment in the morning, they find a burglary, they've already been all through the building, and they know that the perpetrator is gone. We don't need to necessarily respond immediately or like in an emergent fashion. So sorry.
No, I get it. That's why I said we're like they had like vacated the premises. Like I know that's a much lower priority then obviously someone is present, but thank you, Rep. Boyden.
Curious if you know when the last time your staff count was closer to that 90 number.
2020.
Rep. Waters Evans.
This is off topic of what you were talking about. You guys are, okay, I just want to make sure. I'm wondering if you have heard, I know that a bunch of business owners last week or earlier this week in Burlington sent an open letter asking for, a variety of matters of assistance from, the state and the city. And I'm wondering what your interactions have been like regarding this charter and making this change for, not only with the business owners and the establishment owners, but just people in the community. Do you have casual conversations with them about that? What's the feedback you've heard? I mean, I know it was an 86% vote in favor, but.
Yeah, 'cause I can't say that I've had any recent experience with folks related to the charter change, but I have had a great deal of contact with both the business community, residents and visitors alike about conditions downtown. And we have done an excellent job of stepping up our presence downtown using both sworn officers and our community service officers. We're receiving good feedback now, and that's all about getting ahead of this. You have to set a bit of a tone before summer hits. And I'll confess, a long, cool spring helps public safety in setting that tone. But it's our work to be done. And like I tell the cops all the time, we're employed to get into these spots, to kind of quell crime and disorder. So it's shared use for everyone and not worry about the outcomes or the referrals. As that work kind of interlaces with the charter change before you, I think that's, really an important piece of what we could leverage in terms of empowering licensees to do this work, to post their establishments as firearms prohibited, to screen patrons as necessary, and to work with the security staff that operate these nightclubs to make them as safe and vibrant as their business model deserves and needs. I mean, Burlington's always been the cultural hub for Northwestern Vermont, and we've always had to work closely with the host community on a variety of security measures. And I think this is another tool in the toolbox that we can use in a very responsible manner.
Thanks.
Do you have any other questions for the chief? It does not appear.
Okay.
Anything to share with us to close out, chief?
No, I just appreciate the committee's time today and your thoughtful deliberations on this charter change. And if I can be of any greater assistance, please let me know.
Thanks, chief. Certainly will. No, thank you very much and good luck with the job.
Thank you. Take care.
Boyd?
Plan on hearing from the mayor.
We could definitely add that to the invite list. I had spoken to some folks who were representing city and other business organizations to try and find us some business owners. So that request has been put out as well. And yeah, no, I'm open to thoughts on invitations. I do have a little list that some of us started working on here, so we can take a peek at that. So there are a few, we've gone through some of these. I do also want to say the fact that we have a written testimony from the DLL submitted to today's committee page. So if folks haven't seen that, please take a peek at it, read it through. And obviously, if there's any questions within the structure of that, we can follow up with questions from DLL's author of the mission. And we got reports work in 15 minutes. But unless anybody has anything else formal to discuss right now, I was going to get